Thank you guys so much for joining us. I'm Leah Nylen, Bloomberg's Antitrust reporter in Washington, D.C., and we have a great panel here for you to talk about competition policy. I'm going to do some really brief introductions, but the bios are online. Let's see. You guys moved out of the order I had you. But Jenn Hodges, on my far left, is Director of Public Policy and Government Relations at Mozilla. Next to her is Svetlana Gans, a partner at Gibson Dunn. Jennifer Huddleston is Senior Fellow in Technology Policy at the Cato Institute. And next to me, Avery Gardiner is Head of Global Competition Policy for Spotify. So just to kick us off, Avery, why don't we start with you? How, just briefly, do you think the Trump administration will differ on competition policy from the Biden administration?
Absolutely. Thanks, Leah. Thanks to State of the Net for having us and for having this important panel. I'm going to start out and be very boring. I promise to get more interesting as we move through the next hour. Not much is going to change, right? Competition policy is one of those things that stays fairly constant from administration to administration. So overwhelmingly, I expect that we're going to see a continued approach of making sure to rein in the abuses of big tech. There will be other parts of competition policy that will change less related to tech that I'm sure my colleagues on the panel will speak about, but I think most of it is going to remain the same. We're going to see, for example, the Google case, which was begun in the first Trump administration, was carried forward by the Biden administration, is now in its final stages of at least the first part of the litigation before the appeals. I think the new administration will continue to litigate that case. There was a case that the Biden administration brought against Apple. I would expect that the next administration will continue that case. And indeed, at her confirmation hearing in the Senate Judiciary Committee, the Attorney General committed to continuing a lot of these big tech cases. Not every single one by detail, but she did say that these are the sorts of cases she is committed to pursuing. So, sorry, it's a boring answer. I think we won't see a whole lot of changes.
Okay, Jennifer Huddleston, did you have any thoughts?
So I agree that I don't think that we will see a lot changes, particularly tech sector, but I disagree that I think over the past couple of administrations, what we've seen in a pretty dramatic departure from what had previously been seen as the objective consumer welfare standard, particularly in the tech space, and both the prior Trump administration as well as the Biden administration potentially using antitrust to go after disabled industries or to go after other political or policy-related goals. I would agree with Avery that I don't think any of the current tech cases are likely to be dropped by this administration. And I think it's important to remember that the Google case was initially filed during the prior administration. That also illustrates how long many of these cases take and how rapidly in a market like technology makes change. I do think there may be some places where we see some distinctions in that approach and perhaps a awareness of the global nature of the market, as well as a bit of a recurrent some of that consumer welfare standard objective-based approach, away from the presumptions that big and automatically bad and should be skeptical. Two that immediately come to mind. One is in the AI state, that's State of the Net. It's a tech policy conference, so have not AI off of your video courtship. But where we are seeing, particularly in Mike said, this is a very globally competitive landscape. The other is perhaps the minority acquisitions, both particularly beyond the tech sector. The last administration we saw, particularly FTC, that was very likely highly stopped engaged in a high, very strictly and really chill a lot of our direct acquisition activity. I think you may see a bit less of that.
Jenn Hodges, did you have any thoughts?
Yeah, thanks. So, well, first, thank you, and thanks to State of the Net for letting me join this amazing panel here. So I agree largely with what others have said about this is typically a bipartisan space. I hesitate to speculate about much right now, but I think, the changes that we may see in tech, particularly in competition, are possibly less than transitions we'll see in other spaces. Antitrust should be about people, not politics here. I would just say, if I can for a minute, taking a page from Senator Markey this morning, he was talking about the significance of the moment. And I think that's what we're really focused on. Avery mentioned DOJ v. Google, or Jennifer mentioned AI right now. So as we look at issues like that, I think it's really important that we not replicate any problems that we've seen in the past, right? Repeat those patterns. Mozilla is particularly focused, if I can for a second, on competition in browsers and browser engines. It's a really big issue for us, and these are complex, but I think often overlooked technologies. So that's something that we're really mindful of right now. And I guess just two more quick points. I think, right now we are seeing self-preferencing still at play. We are seeing deceptive design patterns that push people towards incumbents. We are starting to see glimpses of anti-competitive behavior in AI consolidation. So I think these are areas that right now, hopefully, we'll see continued focus on. And last point is just that as we see action in these areas, though, in our view, we need to be mindful to not trade competition in one space for another, right? So really take a close look at the stack as a whole. So I'll stop there.
Great. So we are actually moving right into AI. Since two of you already brought it up, how do you think that the competition in AI is going to look like under the Trump administration? We'll start with you, Jennifer Huddleston.
I think that AI is an incredibly competitive market, particularly when you look at all of the stats, and that trying to predict who the leading AI company is going to remind us of looking at all those bullish headlines about security. And if you're not familiar with them, point out things like how Nokia clearly won the cell phone wars, or that Yahoo is the search engine that could never be bought, or that MySpace was a natural probability. We're very early in the AI moment. We don't know what all the applications are. We don't know who all the players are going to be. Many of them are just developing, and then we look at all the different ways that develop all the different levels that it could be done. And we look at the global landscape, particularly, that this is an incredibly competitive market, and that calls to our think that certain companies are monopolies could actually deter really important investment and really important competition along the way. That being said, there are large companies that are investing heavily in AI because they see its consumer opportunities, because they see its research and development opportunities. And we shouldn't assume that just because a large company is investing in AI, that it's automatically going to be a monopolies. And in that oftentimes this is showing that we do still have tech competition, that companies have to compete to improve their autos by doing things like incorporating AI to their
Jennifer Hodges, I suspect you have a slightly different take.
Slightly, though I definitely hear what you're saying, and I think there are some parallels. So Mozilla, our history in the open source movement and kind of antitrust in our DNA, we've been really watching what's happening in the AI space. I think three key points here. We agree we need to look at the entire layers or entire stack, right? Each layer of the ecosystem. Individually. So access to the cloud is not the same as access to data or computing. And we really believe that we need fair access to critical AI resources across the board. Last year's Create AI Act, for example, would have authorized NAIR as part of the development of public AI infrastructure that we think is really critical. Two, open source AI is really important. It's something we believe firmly in, that it really helps promote market access, more competitors, more diverse points of view, innovation, all of the above, right? So ensuring that the US can play a leadership in the global AI, global open source AI sphere is really important. And then lastly, I'd say we are starting to see, in our view, from our experience, some self-preferencing issues of the past repeat. Distribution remains a concern. Some operating systems continue, I think, to use their platforms to preference their own products, and we've encountered that some in the AI space. So something we're very mindful of to keep an eye out as we go forward.
Svetlana, I'd like to bring you into the conversation. Where do you think we're going in terms of AI and competition?
Great, and thank you so much for having me here. So the Biden administration took a regulatory approach to AI, whereas I believe the Trump administration is approaching AI with more optimism and not trepidation, and has said publicly that AI regulation should not strangle the burgeoning industry. So if you compare the Biden approach with the Trump point two approach, the Biden administration implemented initiatives to regulate AI, focusing on safety and ethical development and deployment. In a May 2023 New York Times op-ed article, former FTC Chair Lina Khan advocated for proactive AI regulation to ensure fair competition and consumer protection. Khan argued that the major regulatory risks associated with AI included market concentration, collusive behavior, privacy violations, and discrimination, and called on regulators to act swiftly to uphold open markets to prevent monopolistic control. She stressed several inherent problems with AI, which really foreshadowed her regulation in that area at the Federal Trade Commission. She focused on market concentration and entry barriers. She focused on collusive behavior and price discrimination and fraud and misinformation. When you take a look at what Trump has done in the few weeks in office, he is not focusing on those items. He has called for a deregulatory approach, both in what he has issued as EOs and the staff that he has identified to lead the Federal Trade Commission and the DOJ Antitrust Division. For example, in January of last month, he signed an EO removing barriers to American leadership in artificial intelligence. And that the CEO revoked existing policies deemed as barriers to innovation and mandated the creation of an action plan to sustain U.S. leadership in AI. There might be more reliance in the Trump administration on the private sector driving AI development, which reduces government oversight to accelerate innovation. This approach is aimed at maintaining America's global dominance by fostering a more permissible environment for AI research and deployment. Turning to the FTC, as you know, President Trump has identified Chair Ferguson as the chair of the Federal Trade Commission. He has stated as to AI that a knee-jerk regulatory reaction will only squelch innovation, further entrench big tech incumbents, and ensure that AI innovators move to jurisdictions friendlier to them, but perhaps hostile to the United States. So I think all of these show kind of a deregulatory movement of AI, but even so, there will be continued enforcement in the AI space in both the FTC and DOJ, in my opinion. I think they will be focusing on conduct that is inherently unlawful, including, for example, AI manipulation, as well as AI fraud and deception claims on the consumer protection side. But at the same time, they're going to be more focusing on how to ensure that AI models flourish and that the government doesn't incorporate any barriers, unnecessarily barriers to entry in this space.
Avery, I saw you nodding your head when Jenn Hodges was talking, so what do you think here?
Well, I want to get really, really specific. So first of all, how many Spotify users in the room? Show of hands, please. Raise them high. Be very proud of yourselves. Excellent. Great. Who's tried AI DJ? Excellent. So AI can be used for extraordinary things, and people are doing really innovative stuff, and I'm thrilled to say Spotify is in that category. So when you go home this afternoon, presuming you actually get home on snowy roads that will not be properly plowed, this being Washington, D.C., when you get home, try to use the AI DJ to create a playlist for cleaning the house on a snowy Tuesday, right? And see what you get. And you're all going to get slightly different things because the AI DJ knows you and is building off of super cool technologies. It's really neat. Seriously, do it, and then let me know what your favorite cleaning the house on a snowy Tuesday song was. We are excited about that kind of use of AI, of more ways that we can use AI to delight our customers, and that's why I was nodding along with Jenn on most of the things. From a competition policy perspective, I specifically worry about two things that are not yet happening. So we don't need to take steps yet, in my view, but they're things that we should really be watching out for as competition policy dorks as AI continues to develop. The first is disintermediation. There's the possibility that some of the companies that use these big AI models to power their voice assistants in particular could use the data they get and strip that out of what goes to other services. So for example, if you say, make a playlist for my kid's 15th birthday party, it's possible that the AI engine would not send that request to a streaming service, but would instead create its own playlist and then just give a call out for the songs. That kind of data disintermediation poses the risk of continuing to entrench the biggest data owners today by stripping out the opportunity for anybody else to get that data they need to improve their systems. So it's a future concern I've got about disintermediation. The other one I have a concern about is the potential. And I want to stress, this is not what I'm seeing today, right? I'm seeing a lot of the dynamism that the rest of the panel has talked about. But the risk of lock-in. So there are these extraordinary models that are available, many for free. And companies, and I'm thinking particularly here of app developers, but it could be lots of others, are building on top of those, right? They're using those models and training them for their own purposes. And that training is expensive and requires a lot of investment. I worry that there will be a few of these models that become deeply entrenched and companies won't be able to switch away from them. And so if you are a retail company that builds your customer service chatbot on AI, and I realize we all may hate that, but that is the reality, right, that we're going to see in the future. If they build it on top of one of those models, and then that company says, great, what was free last year is going to be $1 billion this year. Right? That kind of lock-in could be very damaging from a competitive perspective and could lead us to true entrenchment and abuse of power. Again, don't know that it will happen, but over the next few years as this space develops, those are the two things I would encourage us to be particularly mindful of, disintermediation and lock-in.
Great. So one of the things we discussed sort of in our prep for this panel was how there is a little bit more divergence between the United States and other places around the world in regards to competition policy. So I'm just going to give a brief overview of some of the stuff that is going on in Europe for those who are not as nerdy and into competition policy as we are. So in the EU, they adopted a law called the Digital Markets Act. It went into effect in March of 2024. Under this law, they designate what they call digital gatekeepers. And these digital gatekeepers have certain things that they are not allowed to do and certain things that they are required to do once they've been designated. The companies that have so far been designated as digital gatekeepers include Alphabet, Amazon, Apple, Meta, Microsoft, ByteDance, and Booking, the online travel company. Booking is the only one of those companies that is based in Europe. Once these digital gatekeepers have been designated, there are certain platforms of theirs that are required to abide by various do's and don'ts. These are some things like social networks, messaging services, operating systems, and browsers. And the EU can look at whether companies are fully complying with the law. They last year opened compliance proceedings against 3 of the companies. Apple over what they said was steering and the use of a choice screen. Meta over what they're calling the pay or consent model, where Meta charges if you don't want to give consent for use of your data for targeted advertising, and then Alphabet for steering and self-preferencing. Those compliance proceedings are ongoing but expected to wrap up in the next month, and if a violation of the law is found, Europe is allowed to fine the companies up to 10% of their global revenue, so we're talking about pretty sizable fines that are possible. Various other countries around the world have started looking at some of the things that are going on in Europe and adopting similar or slight variations. Avery and Jenn, Hodges and I were at a conference on Friday entirely about that. But the one that has sort of gone into effect already is in the UK. It's referred to as the Digital Markets Competition and Consumers, DMCC. It went into effect in January. And under this law, they can designate particular companies as having strategic market status. Once they do that, the company has additional merger reporting requirements, or they can impose conduct restrictions or monitoring. They have announced 2 investigations into whether they should designate as strategic market status so far, and they said that they're going to have a 3rd one before the summer. But the ones that they've started so far are into Apple and Google over mobile devices, and Google over search. So Avery, let's start with you. How has some of the steps that the EU and other places around the world are taking on digital gatekeepers impacted the business? How do you think it will continue going forward, and how do you think the Trump administration might play into some of this?
Thanks. Okay, so the key word here is gatekeepers. We're talking about companies that control the interface between companies and their consumers, right? So the only way to get Spotify on your iPhone is to go through the Apple App Store. In that way, they are a gatekeeper under this law as designated by the European Commission. We are waiting for them to comply. One of the things that the DMA says is that you have to allow app developers to communicate with their customers free of charge. Apple came out with new proposals that have very different complicated systems, but it's some version of either pay 20% or 10% or 17% or 27% based on the different sets of rules. That's not free, right? It says you must allow people to communicate free of charge. Free means free, and that's why there are these non-compliance investigations. So we are incredibly hopeful that the DMA can open up extraordinary opportunities for Spotify and for other app developers in order to delight consumers with new stuff. And we think that those benefits will be for companies on both sides of the Atlantic and probably globally beyond that, right? Some people have said this is about targeting American companies. It's not. It's about targeting gatekeepers and making sure that we keep markets free, open, and fair. That's what we're hoping for. That has not happened yet in Europe. I am hopeful that there will be compliance. There's going to be a lot of attention next month, in all likelihood, as you mentioned, as these investigations wrap up, on how big the fines are, because 10% of global turnover, that's a lot of money. I think what's more important is to not focus on the fines. It's to focus on compliance. Because when these companies are actually complying with the law, that's when the markets open up. That's when there's opportunity for new business models to develop. That's when there's the opportunity to lower price. I'll give you an example. Spotify is not permitted by Apple to tell you how much a premium subscription costs. Nor can we tell you that you can go to Spotify.com to find that out. Markets don't function well when consumers don't have information about prices, right? When's the last time you bought something sight unseen without having any idea how much it costs? So markets will function better. They will be more free, more competitive, more fair when this is fully enforced. There has, just to get to the final part of your question on, is this a political problem, right, with the next administration? I don't think it is. There's been a lot of speculation in the press. I think that's misplaced, and I just want to point to something, if I can open my phone, that Vice President Vance said this morning in Paris. He said, this administration will not snub out the startups and grad students producing some of the most groundbreaking applications of AI. Instead, our laws will keep big tech, little tech, and all other developers on a level playing field. That's consistent with what we've heard from the Trump administration for years, what the nominees for the new roles in competition policy have said. So I think there's going to be a lot of posturing and a lot of talk about it, but at the end of the day, we're going to make sure that we keep big tech, little tech, and all other developers on a level playing field. That makes sense to me.
Jennifer Huddleston, I think you have a little bit of a different take.
I have a little bit of a different thought. It also is probably a little bit of a different thought on what I think we've seen at these early days of the Trump administration. And part of my different thought comes from I believe that competition policy is part of welfare policy. And that's been my understanding, how we traditionally operate this in the US, which means that at the end of the day, the focus should be on what the consumer, not on competitors. Competition necessarily means that some competitors are going to lose and some are going to win. Our question shouldn't be, why he is so big? Our question should be, are they big because they're somehow engaging in manipulation? Or are they big because consumers like them? And actually, one of the things we have out of Europe now is evidence that consumers like some of these companies, that they're choosing Google when they're given the choice, and that they're frustrated by having to make that choice and having to go through this additional friction, and that we're seeing that companies were supplied these things not because they were trying to do some sort of shady backroom things, but because it's what their consumers wanted. I do think we have seen a difference in the two administrations when it comes to Europe, but that there was evidence of the FTC cooperating with European regulators to try and go after some of America's leading tech companies in ways that they couldn't have be successful in the courts here because of that objective consumer welfare standard, and that very early into the second Trump administration, they've seen that President Trump has called out these laws as targeting American companies, as effectively being a tariff on American tech companies. I think we also have to ask, why is it American companies that are the ones on that list? Why are they the ones that are legal safekeepers? And some of that goes to the overall policy that we see for Europe. Europe wasn't able to have a policy environment that bred startups, that bred success, because it chose to overrange, that it chose to oftentimes strangle in regulation these early startups. And now American companies are leaders, and Europe's biggest tech export has effectively become its regulation.
Jenn Hodges.
Thank you. Yeah, maybe a quick thought on our experience in the EU, then as it relates back to the US as well. So I think, in our view, or our experience with the DMA, we are seeing the benefits starting to come into play a year on. There is reluctant compliance, but as it moves ahead, we are starting to see users be able to make a choice and choose, Firefox in some cases. And so from our perspective, there are definite benefits. And some of the concerns that we've seen, certainly not speaking, entirely, but some of the concerns that I think we've heard have not necessarily come to pass. Yes, some products have been delayed, but I think we'd ask a question about whether a delay in a product in order to become interoperable or to get rid of some self-preferencing practices that were harmful, whether that would actually be maybe good for the consumer in the long run. So, from our perspective, still waiting to see how it rolls out entirely, but, positive visions at first from us. And then I think as it relates back to the U.S., I think we also just need to be mindful that, not all regulation is built the same, not all jurisdictions are the same. Avery, the UK one. Yes, thank you. So, from my understanding, not a UK expert, obviously, it's far more targeted, right? So more targeted than the DMA and flexible. When we look at the markets, the US, compared to the EU is not, I think, operationally a true sort of single market, right? So there could be other factors at play influencing how the regulation has been rolled out. So I think we just need to be mindful of that and the nuance there. I'll leave it there for now.
Svetlana.
I agree with Jennifer. I think, the regulatory regime of Europe and the United States are different. They start in different groundings. And what is unfortunate with the Biden administration is that they cater to the European approach of tech regulation and not the actual law of the United States. So I think we may see a departure from that in terms of ensuring that the rule of law in the United States is United States law and not the law of other countries.
A couple of you all had mentioned the FTC, which is where we're going to go next. We now have a new chair, as Svetlana mentioned, Chair Andrew Ferguson. The FTC is responsible for both competition policy as well as privacy. So Svetlana, let's start with you. How do you think that the FTC under the Trump administration will differ from how the Biden administration enforced the law?
Continued robust enforcement of both antitrust and consumer protection law, although the decision-making will be more empirically based than it was in the Biden administration. I also think there's going to be a push to return the agency to expert status and not just making decisions that are politically popular or popular of some within the agency. Also, I think there's going to be a move to try to course correct. Chair Khan put the agency in a position that threatens the agency's future existence, whether it's Part 3 litigation or rulemaking. So I think there's going to be momentum to try to undo some of the more norm-breaking procedures and process that the Biden FTC started. There is also going to be more focus on enforcement that is within FTC statutory authority and less focus on broader societal objectives that was explored in the Biden administration. We'll continue to see focus on high impact markets like healthcare, food, agriculture, retail, big tech, as well as labor. But I think at the end of the day, we're going to see more targeted enforcement focusing on clear antitrust violations, clear consumer protection violations that should hopefully create a more predictable regulatory environment and enhance market stability.
Avery?
I think that we have a really important reliance on the FTC moving forward. As everybody in this room knows, Congress hasn't figured out how to pass privacy laws, at least not big, broad, exciting ones, and I don't see that changing in the short term. And we don't seem to have the political will to create a specialized agency that looks at tech. So given that we haven't done those things, the FTC is going to continue to be the center of the universe when it comes to questions about technology, data, AI, and other related stuff. So I think Chair Ferguson is very smart and capable, and I think he's got a big challenge ahead of him as the agency within the federal government that has to do a lot of this stuff as it's emerging. And one of the things that came up earlier is that antitrust cases historically are super slow. That's absolutely right. That's not just true in America, that's true in Europe, it's true around the world. These things take years and millions of dollars, and that's probably a whole separate panel on a different day. What that means, though, for fast-moving digital markets is that our litigation system is not the perfect vehicle to deal with some of this stuff that moves super fast. Because in my experience, if you want to do a startup, you can't say to your funders, hang on, 6 years from now I'll get a case decision and we'll then appeal that up and come down from the Supreme. So I'll be ready to use your money in 8 years, right? That's not something that works in a startup investor space. So I do think the FTC is poised to do really great things in this space. But they do have a hard job of figuring out how do you move swiftly and get things right when other parts of the government haven't been able to create the new laws. And I'm not, by the way, I'm not blaming Democrats or Republicans. This has just been a failure of our system to figure this out in the last few years. And so the FTC has some important authorities in the FTC Act, and I think it's going to have to take some of this out for a spin as technology continues to advance, improve, and get more complicated.
Jennifer Huddleston.
So to pick up on something Avery said, I think one of the problems is that regulators can't predict the future any better than the rest of us. And it's concerning when we see attempts to intervene in what are very dynamic markets that are oftentimes just emerging in ways that might not actually play out in a number of years. We see this, for example, even in the current Google case, where the idea that AI might revolutionize search was kind of rejected as part of the decision. And yet many of us are sitting here at a big end moment, not knowing where it's going to go and recognizing that it may fundamentally change everything. Oftentimes it's been innovation that has been our best competition policy here in the US. We can't just look for the next Google, the next Facebook, the next Instagram, the next Twitter, because what actually comes next it is so blatantly different that we don't recognize it as in that time. I also think it's really important when we're talking about competition policy that we're thinking about competition policy antitrust. Unfortunately, over the past several years, in both kind of populist circles as well as in progressive circles, you see calls to use the antitrust for other political goals, whether it's data privacy or concerns about content moderation or just disliking the industry. And when that's done, it takes away that objective feature, and it also is very for both for in terms of dealing with actual competition problems in some of in those cases, but also with achieving those policy goals. If you try and break up a tech company that you're mad at content moderation, it's not going to necessarily change the content moderation strategy. If you try to use antitrust as a tool for data privacy, it's not going to get you a better data privacy standard. And so I think that Cash should be sure that we were talking about antitrust competition, that we're talking about Apple competition issues, and not any of the array of other policy concerns and debates that many of us on this panel also are engaged in.
Jennifer Hodges.
Yeah, no, agree with a lot of what's been said. I think, as others have noted, there are some fantastic people in place at the FTC now, and, heard positive soundings from many of them, including Chair Ferguson, about what they may do in terms of looking at tech and the overall health of the internet. So, hopeful that that focus will continue. if maybe a plug for one thing that I think would be interesting in a bipartisan fashion. You had mentioned the FTC has a remit for privacy and competition. Deceptive design practices are something that we're really focused on, and I think that's an area where we see people traditionally think about them in the context of privacy, which makes sense. So nudges that push you consumers towards doing specific things. But we've also found that it's a real competition issue, where people are sort of pushed towards certain products or whatnot. So I think that this is an area that, as we look at the remit of privacy and competition, the focus on the consumer, that they could really be a differentiator in. But I'll stop there.
Svetlana.
The FTC does have rulemaking authority to do consumer protection rules. But the question is that really the proper role of the FTC in a space like privacy and data innovation, given the fast-moving nature of the industry? There are other tools the FTC has in its toolbox that could inform the congressional discussion on potential privacy legislation. For example, the policy function of the FTC, it had been convening a lot of different important thought-provoking issues on AI and privacy. And so I foresee the FTC continuing that policy focus and taking all the tools in its toolbox, but not necessarily rushing to regulate, because there are a lot of things that it could do in its place, including case-by-case enforcement. What we can't happen is what we saw in the Biden administration, where they wake up and they just change the rules the next day. Like the fact that the Biden administration said, okay, notice and choice is dead, and you're like, well, what am we supposed to do with that in terms of actually complying and building a privacy program for companies? Like, that's where you can't have these sharp turns in terms of where the policy is. It has to be an incremental approach within the statutory authority of the agency.
Great. We're going to open it up to audience questions here in a minute, but whoa, very, very eager. But first, I just wanted to have each of you, what is something in sort of the competition antitrust policy space that you're looking forward to over the next year?
I'm looking forward to opportunities in Europe and what that will mean for the rest of the world, because when European consumers are getting options that don't exist other places, that is ironically going to cause competition globally to bring those same advantages around the world. So I think that is very exciting. I think we're on the cusp of it, and I think it's going to unlock opportunity for businesses everywhere. And that's super exciting to see what is the next exciting new app or exciting new feature that somebody can develop.
We'll just go straight down the row.
So basically, to in some ways pick up on what I said in response to the last question, I'm very excited to see how innovation changes this conversation and hopefully brings back revelation of how dynamic these markets are. What we saw a few years ago was something like ChatGPT, honey, direct cookies, changing our way of interacting. How do we continue to see these markets evolve where we're not just thinking about them as they exist, but what they could potentially exist as, in terms of allowing us to have all the benefits and innovation that we're seeing from having that light touch approach that has allowed American companies to be so competitive, not only here in the US, but also abroad.
Svetlana.
Very interesting time in competition. I think it's very exciting to be in this space. We may even see congressional reform and the initiatives that will come out of both DOJ and FTC should be very exciting. So I'm looking forward to seeing what happens and what unfolds.
And other Jenn.
Thank you. I'd love to see congressional action. This one's hard, Leah. I think maybe a better consumers and people online, general users of the internet, better understanding how competition impacts them, right? As AI is becoming real for everyone, or I'm going to take inspiration from you, Avery. Thinking about Mozilla specific here, who here knows what Gecko is? Okay, that is Mozilla's browser engine. There are 3 browser engines left, primarily 3 browser engines left, Mozilla's, and then Apple's and Google's. And a lot of people don't understand what a browser engine does, but it's actually really important to, how people make choices online. So, that's specific to us, but more generally, I think I'd really like people to understand how these decisions that are being made impact their day-to-day.
Great. So we already let's start at the back and then we'll move up.
Thanks, Courtney Radge from Open Markets Institute. So it's interesting to see this kind of myopic view of U.S. innovation and this idea that protecting big tech, somehow they had, an advantage, but we protected them in our trade law. We've restricted other countries' abilities to regulate their own digital markets. And competition authorities around the world have found that there was anti-competitive conduct by a lot of those companies. So when you're talking about, regulation preventing innovation in Europe, empirical evidence actually shows that it's more about how much venture capital is available, the education and company pipeline. So there's a lot of other factors, but this kind of like ongoing myth about, US innovation. When we see DeepSeek, shows that actually robust competition can lead to real innovation as opposed to like innovative apps that serve up CSAM to children. So I guess my question is, what would you see as a priority for actually promoting competition and innovation on products and services that serve fundamental needs and core things that will make people's lives better, not just like another ride-sharing app or great DJ, that's cool, but we need like innovation, for example, like DeepSeek that will fundamentally alter the environmental costs of AI. So kind of getting away from this end-level application innovation and like true innovation at the back end scientific level. Could you talk a little bit about the conditions needed for that?
I can put in a quick pitch so I think especially, you mentioned the AI angle. I just harken back to my comments on open source. As, from our perspective, it is a real driver of competition, again, of meeting needs for a diverse range of people, right? Varying interests, not just those who have access to all the infrastructure you need in the AI space. And I know people have talked about the pros and cons of open source. It is a spectrum, right? It's not just a binary here. So I think from my perspective, those real changes and seeing DeepSeek with elements of open source flourishing, I think is instructive on this point too. So that, from our perspective, that would be a key enabler.
I would just add, I agree about open source. I think we need to have a variety of options on the market. I do get concerns about calls to regulate open source or submit open source, but I think that plays a role in the AI market. I also think it's too early to predict what the balance between open and closed source is going to be. That's just like the market that's going to depend on the nature of the product. I do get very concerned about the idea that the government should, through some sort of industrial policy, direct our innovation. Should get that. This is something that at times in rhetoric from both some on the left and the right. While it's certainly a very exciting thing when it comes to AI, you're going to talk about an AI race, and it's something that you want to make sure there aren't barriers for the kid in a dorm room who's willing to get this course model to provide that next auction. We also don't want to get a world where the government is saying this is how it needs to go. Because when we look at past history, the government has been really bad at predicting exactly where the technology needs to go. I also am hesitant to say we should have just went another ride-sharing app, because we do see apps pop up and fail all the time. And you also never know what skills the developer of that app or of that service is learning. So you may see that even you don't think the app really is needed or serves a consumer, that there are things that individual is learning, communities that are formed, they're still adding value with the market. So I get very hesitant to this kind of idea that we should dictate how innovation or technology is. Okay, how about Ruth?
Hi, I'm Xander Arnaud with the Knight Georgetown Institute. I guess I wanted to ask. I hadn't heard this topic in this conversation yet. Unexpectedly, divestitures. There's been a lot of openness, I guess, to the idea of breakups on both the left and the right the last couple of years. And I guess I just wanted to ask the panel their thoughts on the prospects of structural remedies for promoting or undermining the cause of promoting competition.
I'll try to answer that. It's a very hard question that you've asked. Whether divestitures make sense depends on what problem you're trying to solve, right? So one of the concerns that I have is that really the only way to get onto smartphones is through app stores, right? So 91% of American adults own a smartphone. We spend an average of 4 hours and 37 minutes per day on our phones. In this room, by the way, I bet that average is a little bit higher. And we check our phones 58 times a day. If you were to divest an app store from the phone operating system maker, that doesn't necessarily solve the problem because there's still the exclusive way to get onto the phone problem. There are other places where there might be sensible divestitures where the vertical integration itself is the source of the problem. So I hear a lot of talk about divestitures. They're hard to get right, I will say. It puts companies in a weird spot to have to sell something at a fire sale price supervised by a judge. That itself can be market altering. So I don't want to say that divestitures don't have a role to play. They absolutely do. It's also very difficult to monitor behavioral remedies because you're trying to get executives to think differently and operate differently than the economic incentives that they face might suggest they do. So I'm going to go back to what I said at the beginning. It's a really hard question. Sometimes it makes sense. Lots of times it doesn't. The alternatives aren't super great either. This is hard stuff.
Does anybody else on the panel want to? What I can say about this, as somebody who has spent a lot of time writing about proposed divestitures of late, the government is seeking a sale of the Chrome browser in the Google case. There's going to be a 2 to 3 week trial on this sort of issue in April. The government is also seeking to force Meta platforms to sell off Instagram and WhatsApp. That goes to trial actually the week before the Google trial, so I will be very busy in April. But I think we will see a lot of courts sort of reckoning with which is easier. One of the ways the government, at least under the Biden administration, had portrayed it is exactly sort of the way that Avery was mentioning. It's like you can have the divestiture and the pain now, or you can have the oversight of it and have the pain for the next 10 years. So which court would you sort of like to have? Okay, I know that we had a couple more questions. We'll come right here in the front.
Thank you. One of the risks of having, say, one company who's in the middle of a commercial dispute with another company is to put only one of those on the panel. And Avery tells us a story about Spotify in Europe. But keep in mind that Spotify has never paid a nickel to Apple, ever, because Spotify does all its subscriptions outside on their website. And Spotify, a European company, has been very successful at lobbying European regulators to try to force the American company Apple to let them do in-app purchases for no commissions. So that's more of a factual account than Avery's, but Avery, you're an expert at what your company has, but it just isn't fair for one company to give their side of the story without a little balance. And I ask you, Jenn, too, where is the consumer harm when two companies are having a commercial disagreement over money they pay to each other?
So we've often seen this come up in kind of the App Store donated questions of, is there a monopoly in app stores, particularly as it relates to Apple and its kind of closed ecosystem? Or is this actually more of a contractual dispute? So if Spotify or Epic Games or some other company doesn't like what Apple offers it in terms of the deal for being in the App Store, it can choose not to operate itself in the App Store the same way that there was a brick and mortar shopping mall. If you don't like the terms of the shopping mall, you can choose not to offer yourself the shopping mall. I know Avery feels that basically the only way you own iPhones is through the App Store, and that's been one of the way I've used. But you also see that people can go to Spotify.com, and there's also a question of what does the market actually look like in these cases? Is this a case where the market is just iPhones, as we've seen attempts to define it, whether in Europe or in series US cases? Or is this a case where it's all devices that can stream music, which make a very different scenario when we're analyzing what the market is? I think one of the key elements to the debate about antitrust, regardless of how you're looking at it, whether you're looking at it as a policy expert like Hulk, or if you're looking at it with one of the companies that might be engaged in one of these disputes, is the question of what that algorithm is. And that's largely what I think we oftentimes are seeing debated, particularly around tech companies. Because these tech companies were so new and dynamic, what is that market we're actually today? Is it the browser engine? Is it the streaming services? Is it devices that play music? Is it everything that can entertain you? And I think it's very important that they not lose focus on what the consumer experience is. That this isn't just about companies with each other, that it's also about what is that consumer experience, so that we're getting the most accurate reflection of what that market actually is.
So I want to take us back in time. Spotify predates the iPhone. And you'll remember when the iPhone came out, and it's an extraordinary piece of equipment. I carry 2 of them everywhere I go. And remember the tagline Apple had? There's an app for that. There's an app for that is what brought people to the App Store. It's what made people want to buy iPhones. It's because there was an app for that, and you could go to the App Store and get it. And a lot of the value that was brought to Apple's App Store was from app developers who created those apps. Apple created some, for sure, and app developers around the world created lots of others. And so a tagline was born, there's an app for that. At that time, there weren't fees charged to Spotify for being in the App Store, probably in recognition of the great value that third-party app developers were bringing to Apple. It was only after they were able to make that super popular and close it down that they started imposing these fees. It's also not true that Spotify doesn't pay Apple. Spotify pays Apple every year. There are the app developer fees to be in the App Store that are required, and of course, advertising services. Spotify is quite happy to pay for services rendered. We always have been, and we always will be. What we don't want to do is pay fees that are not based on market rates, because there is no market rate. That's what we want. We want market rates to prevail. We want competition to be what actually determines the winners and losers, not people who serve as gatekeepers. So, Steve, I think we'll disagree, but I wanted to make sure that we were clear on the history here.
We can take 1 or more questions. Please identify yourself and any organization you're with before asking your question, and try and ask a question. We have one over here.
Hi, Milton Mueller, Internet Governance Project at Georgia Tech. I'm going to feel kind of stupid here, but I'm really puzzled about the Google decision in which Google was ruled to be a monopoly. Now, when I'm teaching antitrust in communications to my students, I emphasize the importance of market definition. You can define a market in which anybody would come out as a monopolist, and you could define it in a way that nobody is a monopolist. But in this case, it seemed that the judge defined the market as something that is very obviously, to me, not a market. That is search. Like, nobody pays for search. By definition, that is not a market. Search is their way of attracting eyeballs so that they can sell advertising. The market is advertising. So what am I missing here? How does a major court decision in a huge stakes case get this decision that they have a monopoly over a market that doesn't exist? And why did Google not make that argument?
I don't know if anybody wants to take that one, but I will say there is a 212-page decision you could read that probably would help.
I've read it. I'm not convinced.
I'll hop in a little bit, because I actually think the question is even bigger than that, because first off, it's not fully defined as a monopoly in search. It has to do with general purpose search engines and default agreements as relate to those. You'll oftentimes see it shorthand as a monopoly in search, but I think it's actually much more narrow than that, even in terms of what it was their type of monopoly in, which, to your point, you can define things narrowly enough that it looks like anyone has a monopoly at anything almost. That being said, I think it's very interesting, 2 of the points that were rejected by the judge with coming up with that general purpose search engine definition. One was the idea of that specialized search engines are competitors. So if you look at the data, Gen Z increasingly is video first search. So things like TikTok, YouTube. We also see a rise of the number of specialized searches. So you see a rise of the number of searches that serve on Amazon or via voice or things like that. The other was he rejected that AI was close enough to a competitor. that could change this. So I think that when we're talking about market competition, that was very interesting. But then I think this also relates to the very interesting question of what we're now seeing for hostess remedies. So this case was about search and default agreements, and yet one of the proposed remedies is to sell off, which does not relate to that portion of the case. And particularly we're talking about things like browser engines could have a much broader impact on an entirely different market as well that was not the subject of this antitrust litigation.
Does anybody else want to?
I don't have an answer to the question as not being an antitrust lawyer. But to Jennifer's point, I will just say, I think it is true we are thinking in the broader context that we do need to be mindful, as I've said, I think in different contexts throughout this, of being aware of the whole stack and competition across the board, and being sure that as we move forward, decisions are made, that we aren't trading competition in one space for competition in another, and we're mindful of that holistic approach.
I think we have time for one more, if there is one. If not, I will, in fact, let you all go a few minutes early so that you are on time to the last panels. All right, thank you guys so much. Please welcome our panel.